jail reports. I spent more time on jail reports than I did PSIs.
From the very beginning, you can see the warning signs. The judge is already citing reports from inside the jail, and that's rarely a positive signal. A negative record behind bars doesn't stay locked away. It travels straight into the courtroom and shapes how decision-makers view credibility, discipline, and readiness to follow rules. It raises a tough question. Should conduct while incarcerated carry this much influence over sentencing, or should it be treated as a separate issue altogether?
They're more voluminous.
Same names I keep saying. Let's see. So we are going on the MTRP in one new case. Let's go with this new case 25. Good morning. Are you Jacqueline Young? And Mr. Lewis, will your client waive the formal reading of the indictment and the motion?
He does, Judge.
Mr. Young, in cause number 250309, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from February 26th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up.
Evading arrest with a vehicle is a serious charge in Texas, and it's far more than a simple traffic stop gone wrong. When it rises to a third-degree felony, the consequences become severe, carrying the possibility of up to a decade behind bars. It catches many people off guard. The reality that fleeing in a car can trigger penalties nearly as heavy as those tied to far more serious offenses.
And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Speak up. Because let me tell you something. I bet you're not talking that low when you're acting up like all these jail incident reports tell me. When you're calling names and you're acting a fool out at the jail. So use your big boy voice and answer my questions just like you do when you're acting nonsense to those correctional officers out there. Because I bet you're not whispering to them, are you?
The judge shuts it down immediately, calling out the contradiction. If he can raise his voice at correctional staff, he can certainly speak up in court. This goes far beyond simple etiquette. It's a direct test of credibility. Acting timid in front of the bench while showing aggression behind the scenes sends a clear signal, and the judge reads it instantly. In that moment, it becomes a turning point. Either a calculated attempt to manage perception, or a misstep that undermines his own position.
Are you? Okay. Because how you act at the jail, how you act right now, all determines whether I even go along with this plea agreement. I don't have to. You're on a probation. I don't have to take plea agreements on any probations. If I find that you violated your probation, I can give you anything I want to in that range of punishment. And I can say, you know what, I'm not going to let you guys negotiate. That I don't have to do that legally. So you better be careful with your faces and your words and your attitude, because I've read all of these and I already don't have a good feeling. Do you understand? So you need to give me a better feeling if you want me to go along with this plea agreement. Does that make sense? Okay. So
this is a true legal turning point. Judges aren't obligated to accept plea agreements, especially when probation violations are on the table. In plain terms, the prosecution and defense might settle on 5 years, but if the judge believes the defendant's conduct reflects ongoing disregard for the rules, she can reject that agreement and impose a harsher sentence within the legal limits. That's the weight of judicial authority. Measured, decisive, and capable of reshaping the entire outcome in a single ruling.
Again, before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in that case?
No objection, Judge.
It's admitted. Is there any evidence that Mr. Young is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 5 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Now, in cause number 21-37857,
Your Honor, it's a second amended. Just in the interest of economy, I would suggest we go forward on counts 1, 2, and 13. 13 being the offense he's already pled to.
okay, let me look at it. Thank you. I got it, thank you. So I have a second amended motion to revoke your community supervision. So you're on probation. We've got a probation for an evading arrest or detention with the use of a vehicle. And we've got 2 more evading arrest or detention?
The second evading is a misdemeanor enhanced to a state jail. And
Oh,
count 20
right.
reads motor vehicle. That's incorrect, Judge. It's evading on foot
Okay.
with priors.
Okay, gotcha. So this shows that you were placed on probation August 29th of 2022 for evading with a vehicle. And that was a 10-year sentence in prison that was probated for 5 years. Is that correct? And the state's elected to proceed on counts 1, 2, and 13. Count 1 alleges that you failed to report as directed to the probation department on October 2nd of 2024. And is that true or not true? Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? And then count 13 alleges that you were arrested for the offense of evading arrest or detention with the use of a vehicle February 26th of 2025. And is that true or not true? What's the status of the possession and the failure to ID from that date?
I believe the failure is, I think, still pending. The misdemeanor.
The failure ID is still pending next door, Judge.
And examining the probable cause affidavit from that date, I don't see that there would be a possession charge, Your Honor.
Okay.
I will double check and see if there's, I didn't see anything else like filed or pending. At this point, I'll check and see if there's a lab report pending, but I don't think that's been filed.
Okay. So, let me look at something real quick. What I'm looking at, just so that you know, I'm trying to go back and find which administrative hearing talks about the allegation of his behavior to, it looks like there was something that happened with probation, one of the allegations. So I want to see a little more about that. That coupled with what's been going on in our jail may or may not affect my same thing. It's the same thing. You did the same thing to your probation officer that you're doing in the jail. Do you really think that your probation officer is going to go on a date with you? Do you really think that a correctional officer is going to go, yeah, when you get out of jail, you're the guy I want to date? You got in trouble for saying and talking like that to your probation officer, and now you're doing it when you're in jail. Cursed loudly about the work you had to do for your community service, calling it slavery.
And there it is, the moment everything tilts. Dismissing community service with a remark like that in front of a judge is a critical misstep, similar to openly insulting a supervisor during a performance review. In the court's eyes, community service represents an opportunity for accountability and redemption, not something to ridicule. When it's treated with contempt, it sends a powerful signal about attitude and responsibility, leaving observers to question whether such comments reveal simple immaturity or a deeper, deliberate defiance of the system.
You think community service is slavery? Do you think that?
No.
It's the same. I'm not taking 5 on the MTRP. I've already taken 5 on the other. Y'all can renegotiate or you can let me do it. So I'll hold everything right now. Y'all go visit some more. But that's the same behavior. We're not gonna reward that. All right, y'all go visit. I'll hold it instead of resetting it. I'll keep this paperwork, but I can make a modification if you come up with something different. But I'm not going to do that. Let's see. So I already did that one. All right, so we are back on the record in cause number 21-37857, and again, you're Jacqueline Young, right? And in that case, which is the motion to revoke probation, Mr. Young had entered pleas of true to counts 1, 2, and 13. There was an agreement for 5 years in the institutional division, which I said I would not accept. Have you guys had an opportunity to visit?
We have, Judge.
And what is the...
The new agreement is 8 years TDC.
All right, I'll take that. And Mr. Nichols, that's your agreement as well?
Yes, Your Honor.
All right, Mr. Young, again, I have some documents here, like the other case, that have your signature on them, that the state's marked as exhibit number 1. And before you signed these, did you go over them with Mr. Lewis?
And just like that, everything changes. The 5-year agreement disappears, replaced by an 8-year sentence. 3 additional years added not because the law suddenly shifted, but because of attitude, repeated non-compliance, and visible disrespect in the courtroom. This is the harsh reality of high-stakes hearings. Sometimes the deciding factor isn't legal strategy at all, but personal conduct, where one's own actions can end up shaping the final outcome more than anything else.
Speak up. And you fully understand them also. And I have made the notation with everyone's agreement on the agreed punishment recommendation page that that's changed from 5 to the 8.
Yes, ma'am.
Yes, Your Honor. Thank you.
All right. State tenders number 1 in that case?
No objection.
It's admitted. And so, Mr. Young, I'm going to find that you entered your pleas of true to counts 1, 2, and 13 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with this agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 2 cases will run concurrently, which means together at the same time. As a part of this plea agreement, I'm going to sign a dismissal in cause number 25 DCCR 0385. I'm handing you in each of those cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. When you were here back in 2022, we went over the fact that you're not supposed to possess a firearm in Texas, correct?
Yeah.
Okay. It can still go worse. I mean, I got 2 more years. It's not funny. It's not funny to you, but I know you're upset about all this, but the only person you should be upset with is yourself. You know? So anyway, because of the judgment entered against you, you're not allowed to possess a firearm in Texas. I've handed you that admonishment. Be sure and read it again. We already went over it before.